Quick sound check, Mr. Brown. Justice Apple, can you hear Mr. Brown? Justice Apple, could you hear Mr. Brown?
Would you speak again, Mr. Brown, please?
I'll try that again. Can you hear me now?
I surely can. Thank you.
Thank you.
May it please the court.
Thank you. You may proceed.
First of all, I wanted to thank the court for having in-person hearing as we're having today. I have followed all your supervisory orders for the last several months, and I have to say I've been so impressed with the fact that the court has acted as a fiduciary for all of us, and I very much appreciate that. The way you've taken the effort in this courtroom, the way you're doing the mics, at remote, the way the trial courts are opening this week, thank you for that. Thank you very much. I also want to thank you all for having an oral argument in this ethics case where I'm representing Mr. Akpan. I think this is the kind of case that requires an oral argument. The fact is, we've had a lot of ethics cases we've argued about generally what the facts are, what they aren't, or what the sanction should be or shouldn't. But generally, in front of many of you, not all of you, but many of you, the fact is we don't have that here. Actually, in this case, what we have is a claim was made about Akpan, who's a licensed Iowa lawyer who only does immigration work in Houston, Texas. He couldn't practice any other kind of general law, divorce law or anything like that. That's what he does. And that's where he does it. Okay. So actually, he's charged by the Iowa Professional Licensing Board with violating some rules from Texas. Apparently, the complainant had filed something in Texas. It was dismissed because he wasn't a Texas lawyer, so then it was transferred and something was filed here. So what we have is the Iowa Licensing Board construing what they believe the law is in Texas, involving what was done with an immigration lawyer in Houston. And the case gets even stranger because we raised a question initially on whether or not the complainant would be testifying live. It would have been in this building when we had the case, or was she going to be permitted to testify remotely? And we made an argument of why she shouldn't be permitted to testify remotely, but she did, and notwithstanding that. So we examined her the best we could remotely, but really the only things that stand out is she acknowledged she didn't do the work she should have done to help her lawyer prepare the immigration work, and that she told him to stop because her husband was having an affair with an unrelated female. He did. Later, it turns out she hired somebody else. She lied to the immigration people. Were they having domestic trouble, which is a red flag that you're not going to get a change in status for her husband, and basically then proceeded with some kind of domestic issue. Anyway.
Mr. Brown, let me go back to your first point, because sure, this does present some sort of choice of law problems.
No.
So I understand we're the ones with jurisdiction over Mr. Akpan, true, but we're applying the Texas rules. If we were to find one or more violations, would the sanction then have to be in line with our cases, or would it have to be in line with how Texas has sanctioned similar cases, if we could even figure it out? My initial reaction, tell me if I'm wrong, is the sanction, if we find a violation, would be governed by our authority since we're the board, we have jurisdiction over him. Am I right or wrong about that?
That's the way I interpret it, although I have to admit I've been confused ever since I've been in this case, because it gets even more interesting than that. You get the opinion, which is what we're up here appealing from. And the opinion basically says, from the grievance panel, page 42 of the appendix, 43, that it says, the commission relies almost exclusively on the testimony of the respondent. the commission may rely upon a fact stated by Villatory, that was the lady, to the extent that coincided with the respondent. Thus, even if it's determined the commission should not have allowed her to testify by video conference, such error is harmless. Never seen anything quite like it. And so actually, what they're saying, they didn't rely on anything that this lady said. Nothing. And it's harmless, even if maybe they did. Yeah. Yes, Your Honor, I'm sorry.
There's been a reference to sort of quasi-criminal processes that we would need to put in place for this sort of action. What does that mean exactly? What sort of criminal processes would apply to a discipline case?
Take my best shot at it if I can, Justice McDermott. But it seems to me the real issue here is the court has said many times it's a quasi-criminal matter. The fact is you afford due process to the respondent, licensee lawyer, and basically provide all the process you believe is due to make sure he or she gets a fair hearing. Obviously, that's been done historically here, this court and prior courts, on a case-by-case basis, and I think that's what the law is. I read your opinion from a couple weeks ago, and I read Justice Oxley's from last week, and it seems to me it's a case-by-case basis to determine what's right and fair under the circumstances. But what I guess I would say is, in this case, I don't think anybody could disagree very strenuously. I don't think Wendell does, that in fact this was handled correctly. I mean, the reality is, when you read this decision, at the end, it basically says, we're not relying on anything the complainant said at all. Well, we wouldn't even be in this courtroom arguing if there hadn't been a complainant that somebody at the board level thought had enough basis to file a complaint. And yet at the end, this person vanishes, isn't even part of the hearing. It's just, I mean, I've never seen anything remotely like it.
Let me break down and try and ask you about a couple of things you've raised, Mr. Brown. Sure. All right. For one thing, on the remote testimony, I understand your position that the respondent wants the complaining witness there, wants to be able to assess credibility, wants the complaining witness to be directly in person confronted, and I get that, and there's arguments under the rules that that's required, certainly. The commission made what seemed to me a thoughtful point, which is if we can't subpoena the witness here, and you can't do that because she's in Texas and she's not interested in coming voluntarily, then the only other option is a deposition by you and Mr. Harms of her in Texas. And if that were undertaken, the commission members wouldn't be able to ask questions the way they like to be able to do at these hearings. Isn't that something that should be weighed and balanced into the calculus here?
I think to some degree, Justice, but if even take a look at Wendell's brief that he filed, he's acknowledging the weaknesses they have. So why don't we just vacate this ruling, and why don't we fly down to Texas and take this deposition, and basically I assume we could do it by Skype so the commission can be hearing whatever we're doing, and then there you are. I think that's what he just suggested in his brief. This is after we've been through a 2-day case that really has a very strange flavor to it, that you really, what is the complainant? Next issue is, every case I've ever argued up here and every decision any of you have written on subjects of ethics, as a general rule, there is a comment about you judge the credibility of the testimony. There is not a single credibility finding as to the complainant in this case at all, even though she acknowledges she misled and lied to the immigration authorities. I mean, I had to pull it out of her, but she acknowledged it.
Let's say hypothetically we did truly disregarded all of her testimony and just relied on what Mr. Akpan said. One thing he did is he did get a flat fee. am I right, for this representation of $4,000.
He did.
And he drew down that flat fee, even though he didn't tell her he was doing that, and he didn't have any milestones or in the agreement that allowed him to do that, other than having completed the whole job. Wouldn't that be problematic even under our ethical rules? Now, we have the separate issue whether Texas applies the same framework, but isn't that problematic under our rules?
I don't think it's problematic at all. I mean, basically, what he testified to, so assuming we're only taking his testimony now, because she's out, she's gone.
Well, for purposes of my question,
I'm following up on your question. Basically, his testimony was that he had completed a lot of work before they ever entered into this agreement. So when he got the money, he could put it in his operating account. And I don't think that was even disputed in this case. So by the time this was signed by the parties, and I'm looking at page 64 of the appendix, which is the flat fee agreement, he'd already done the work. He'd earned it. It was his.
Correct me if I'm wrong, but did the contract refer to that the work's already been done, and you owe me, and then this is retainer for the future?
Sure.
Did it break it down?
He didn't, although it makes it pretty clear here that basically what he's doing, legal services involved, and he has two different numbers kind of in the middle of this document. I'm not an immigration lawyer, so don't hold me to what they mean exactly, but I-485, which is one of the immigration forms that needs to be fulfilled, and I-130. And the testimony was uncontradicted that he spent a great deal of effort trying to fill out these forms, but he needed the information from his client, which he never got. And then after he never got it, basically she said, stop, because we're in a situation now where I'm getting divorced, and I don't really want to help out my mate get a resident status.
Mr. Brown.
Excuse me, am I okay time-wise, Chief? Or I'm looking at a red light, and that makes me nervous. Okay.
In a flat fee agreement, you can agree to draw down based upon markers in the case. So you could, for example, say, we're going to draw down 25% at the end of discovery, and another 25% at the end of dispositive motions, and maybe the final 25% or the final portion at the end of the case. In this case, I didn't see anything in that document that indicated any markers, whether it was an hourly rate saying I'm going to draw down based upon $150 or $200 per hour, or whatever his number was, or any other marker. And so what do we have to go on here to know that he actually earned the $500 payments as they were being made?
You'll have to judge his credibility. It's his testimony only, Your Honor. I mean, basically, he said he did the work. He testified he did the work. Basically, after he didn't know he was discharged at that point, but this lady wants her $4,000 back like he'd done nothing, which is simply not accurate, and then turns around and sues him down in Texas. So we have a small claim case pending in Texas right now.
Thank you, Mr. Brown, and you'll have rebuttal.
I can follow on a
Okay, thank you.
rebuttal. Thank you.
Mr. Harms? If you don't mind, let's do a quick sound check with Justice Apple.
All right, testing, 1, 2, 3. This is Wendell Harms.
Thank you very much, Mr. Harms.
You may proceed.
Thank you. Chief Justice Christensen, justices, counsel, may it please the court. I have some prepared remarks, but I also made a few notes. I'd like to comment on those to begin. My view of the world on this issue is that the Texas rules apply substantively, so that's why we charge the rule 1.14, 1.15, and 0.104. But my view would be that the sanction and that analysis of what's the appropriate sanction would be decided under Iowa law. I don't have any authority on that specifically, but I think it's pretty clear from the rules themselves that the Texas substantive rules should be applied. Quasi-criminal. It seems to me that two factors come into mind there. 14th Amendment, or due process procedural protections, and confrontation protections or confrontation issues arising under the Sixth Amendment. My view would be in a disciplinary proceeding, the Sixth Amendment is not applicable. The 14th Amendment, procedural due process, does apply. There's plenty, well, I don't know there's plenty, but there's some case law on that. The Hurd case comes to mind, where the court talked about quasi-criminal. The N. Ray Ruffalo.
On this issue, putting aside the constitutional arguments, what about just under the rules? I mean, 36.176 says presentation of evidence must conform to the Iowa Rules of Evidence, Iowa Rules of Civil Procedure. 3617 says unless it's a character witness for the respondent, the witness must testify at the hearing after administration of an oath. And then 3617.5 says the respondent attorney has the right to be confronted by witnesses. Aren't you somewhat hemmed in what your options are by those rules?
Hemmed in to a certain extent, but I think technology and the safeguards that the commission president put in place with regard to this give latitude for what happened here. The commission required that we be able to see and hear the witness. That happened. The commission required that the witness be able to be put under oath. That happened.
There's no good cause exception. There's no, I mean, the rules are pretty plain here. I mean, absent the consent of the responding attorney, the attorney has a right to be confronted by witnesses. Normally, you would not consider a video appearance to be confrontation, right?
Well, not in the criminal context. That's the Rogerson case, and I believe you may have written that opinion. But this is not a criminal case, and our view, the board's view, is that due process was adhered to here. Now, you know, going way back, we have the Counsel case, which talks about the purpose of these proceedings is not to punish the lawyer. This is not a punitive process. This is a process to protect the integrity of the profession, to deter misconduct, and to specifically deter and to generally deter. If we are in a situation where Iowa lawyers can practice in Texas, and I guess Texas doesn't care, and we can't supervise them or regulate them or prosecute them, however you want to think about it, because the witnesses are all in Texas, well...
But you could have gone and taken a deposition. You and Mr. Brown could have done that, right?
We could have done that. The board offered another option to the commission, and the commission, well, initially, I guess we were living in the Stone Age, maybe, or not the Stone Age, but the telephone age. We got an order approving telephone testimony. And there's been prior cases that this court has reviewed that did include telephone testimony. But then...
An objection, right?
Not with an objection. Then there was an objection here, not immediately, but eventually. And then we moved to the video conference. That also was objected to. The commission president said, well, I'm going to go with the video conference with these specific requirements that I enumerated. Some of them, I don't think I enumerated them all, but most of them. I guess you also had to be actually be able to see the exhibits and so forth. So,
I have a question.
so there you have it. That's the path we took. If that's the wrong path, I guess we'll find out, and we'll be working on our frequent flyer miles, going to Texas and so forth. Now, let me just say one thing before I forget, sorry. You know, we have other complainants who are in prison. In fact, the next case of Mr. Brown and I involve complainants who are in prison. So I guess we'll have to, if they have to be called to testify, and I'm not sure that they will be, but if they are called to testify, I guess we'll have to talk about whether or not we're going to take the commission down to the prison or take their deposition ahead of time. So there are constraints with regard to a nationwide ability to have a nationwide practice and/or clients who are incarcerated. I'm sorry, Your Honor.
Speaking of nationwide, I want to go worldwide. We have a pandemic now, and I've entered lots of orders since I started this gig, and I think one of them was giving ADB permission to do video conferencing, like everyone else. This case preceded the pandemic, correct? The trial?
Yes.
So
This
could you
case-
address that? Isn't that kind of a way of us saying out loud that that means normally there wouldn't be? Well, you can correct me if I'm wrong. Didn't we have an order saying that the ADB could conduct their hearings virtually? Or that the testimony could be taken virtually?
I guess that's possible. I've never thought of it that way. I viewed these these orders that have been coming out from the court, really addressing a forward-looking problem, not reflecting on, well, now this defines how things used to be. It seems to me the rules that Justice Mansfield cited, the commission protected or adhered to or followed or honored each of those rules. We could see Ms. Villatoro, we could hear her, she had the exhibits. I think it's outside of a criminal context, I think it's form over substance to be that wound up, if you will,
Mr.
about
Harms.
the technology.
Could you address briefly the evidence relating to the unreasonable fee and what your theory is with respect to that violation?
The theory of that is that based on just generally what happened, based on Mr. Akpan's testimony and the exhibits that were presented, and based on the expert witness testimony of Joanne Barton from Ames, was that he did not complete the case. And without milestones in the contract, there's one payday. And that payday is when you submit the case.
That would be under the contract, right? But
Yes.
then what happens is she fires him, all right? So then it seems to me he's then entitled to assert some kind of quantum merit for whatever amount he feels he's earned based on the work he's performed. And in this case, once we're in a quantum merit, he had hour after hour on the case, right? Because of all these trips that he had to make over there to try to get information that he wasn't able to get from his client.
Now, let's be clear about what these trips were. He's driving, this is a 2-hour trip, he said, to go from his home or his office to this woman's office for the purpose of talking to her about, does she have other documents? You could obtain that information by telephone. You could obtain that information or documentation by the mails, United States Mails or FedEx or some other service. Driving across town a bunch of times to say, well, now I've earned the fee.
This relates to my question then, I guess, and the one I asked earlier. It's really not the board's contention that he didn't do the things he said he did. It's your view that driving across town repeatedly was just unreasonable in terms of prosecuting or representing her in this case.
Well, under Texas law, I think it has to be unconscionable, and we think it was unconscionable. Yes, it's churning so you can. We're not in a situation where you can churn the file and then say, well, I churned the file for hours, so I guess I'm entitled to it.
Mr. Harms, I want to get to the sanction here. The commission doesn't cite any case in coming up with its 61 days. What case do you point us to that would support a sanction in this case?
Well, I didn't cite any either. I cited the standards.
Yes, you did. Correct.
And to some extent, I suppose I was a little bit up in the air about what applied, what law applied. Now, I said today that I think we probably really need to look at the Iowa case law with regard to the sanction. But
Well, I'll push back on you a little bit here.
I'm sorry.
I'm sorry. I will push back on you a bit here. the respondent points to the Said case, which had the violation that was found here on top of a number of others, and the total sanction there was 30 days. And that case involved a lot more than this case. And so
Yeah.
how do we get to 61 days in a case like this when the Said case from, I think, 2013 was 30 days and involved a lot more?
Yeah. Well, in answer to your first question, off the top of my head, I would come up with the Piazza case, which, as I recall, was a public reprimand. Mr. Piazza put a significant sum of money in the desk drawer on a Friday afternoon, drove all around Warren County over the weekend, and claimed to have earned it all by Monday morning. And I believe that the Piazza case, it's the most recent, and I'm not talking about, maybe it was his brother's case. There's a couple Piazza cases, but it's the most recent one. James, I think, is his first name. So what are we doing here? The 61-day suspension is probably out of the ordinary for what the court would have imposed in prior cases, if we just look to that. And I conceded today that that's probably the place to look. But then I did cite the standards that you referred to in your recent opinion. And what I really think the commission was facing here was that we had an Iowa lawyer in Houston, Texas, who based on the testimony and looking at the exhibits, was somewhat clueless about how to practice law, or at least how to manage his own law firm. And that's why the commission recommended that you order him to go to some classes, Texas-based classes, to improve his skills with regard to office management, solo practice, trust accounting. He said he wasn't even sure he had a trust account. I mean, how can you not be sure you have one? Either you do or you don't. So how do we do that when the lawyer is so far away and so forth? And that's, I think, why they recommended the 61-day suspension, to give Mr. Akpan some time to get to these classes. The court can then take a look at him at a reinstatement hearing to make a decision, or to see that he's taken some steps to improve his skill set here. So it's at the high end of reasonable, and maybe it's beyond the high end of what the case law is. But I think that's the thinking, and I think that's the rationale that the court could use, should it choose to do so, to help Mr. Akpan not get in this situation again with how he writes a contract, how he handles the money that he's paid, and really has some business sense about what clients expect from lawyers and what one can reasonably charge for what one's doing. To say, well, I drove around Houston a lot and I'm entitled to $4,000, we need a reset on that kind of thinking. What was the result? What happened? Is unconscionable, didn't put it in the trust account, didn't even offer an accounting, much less, even yet at the hearing, he still hadn't offered an accounting, and he had no time records, he had nothing at all. In writing, he had his testimony. So the sanctions, pardon me, yes, the sanction is a tough call, but that's, I think, the rationale for 61 days. We don't have probation. We'd like to take another look at this lawyer. Thank you.
Thank you, Mr. Harms. Mr. Brown?
Thank you, Your Honor. I think I'm understanding the mic this time, I think. I don't
Make
think,
sure Justice Apple can hear you. Can you hear Mr. Brown?
I can, thank you.
Thank you, Chief, and thank you, Justice Apple. I don't think this court has adopted these standards. You cited them in your opinion, Justice McDermott. I think Justice Wiggins was pushing for it. But I think in a decision, I think that Justice Mansfield wrote, I think he indicated if we're going to change the ethics rules, we better have a hearing on it, just like we did when we adopted the model rules back in 2005. And I think, in fairness to it, I think for Wendell to be citing that as authority and binding authority is simply not accurate. I don't believe that's doable. The other thing that I think is concerning me here as we go through it a little bit is Wendell's conceding this is a sanction. He doesn't know where they came up with it. I don't think anybody knows where they came up with it. Actually, if you read the decision, they don't tell you how they came up with it at all. Nothing. Basically, they just say 61 days, no authority cited. They did say at some point, I think maybe the page earlier, well, basically, we're aggregating all these rule violations. So there you go. That's it. And that's on that basis, we're going to take essentially nuke a minnow down in Texas based on this record. The idea that you're actually going to discipline this lawyer based on this record is, I think, outrageous. I think when you read the entire transcript from the start to the finish, whatever it is that is going to be weighed or not weighed with the complainant, whatever he said or didn't say, and then the arguments that we made at the conclusion of the case, we didn't consent to any case being tried other than the one that Wendell sued us for. I mean,
Well, let me ask a question or two.
certainly.
As I understand it, the original agreement stated that no services would be rendered until the first payment was made. And then he turns around and charges for pre-agreement services. Now, we don't need testimony from anybody on that other than your client. And the commission found that to be a violation. And wasn't it so? Am I missing something?
No, I'm sorry. I wasn't meaning to interrupt, Your Honor. Were you done?
No, I am, thanks.
I think the contract was valid. I think what he testified was accurate. I think he'd earned it. The fact that he probably could have written the contract a little differently.
Yeah, the contract doesn't provide for it, if I may push.
If I could finish. I actually think everything being equal, and it was consistent with how he testified, that he'd done the work. He wasn't driving sightseeing across Houston. The fact is he was going across Houston because he needed to get documents approved, signed, and she needed to get him this thing. If she was unable to get it to him, he had to go back over there and try to get it. He wasn't just driving over there. And as far as relying on the mail service, this is the first time I've heard in recent memory any of us are going to rely on the mail service. So in terms of certainly right now, relying on the mail service, the fact is he's attempting to get the information. He's attempting to follow through with it. And ultimately, he not only got fired, he was told by the client, quit working on this. So he did. And then at that point, she says, you haven't done anything for me. I want all my money back. And he didn't give it to her. So here we are. And there he is in court in small claims down in Houston. It's still pending. It was stopped by the COVID court breakdown with in terms of restrictions. And I don't know if this case will ever end. But the idea that really we see it as our role as the Iowa licensing group to reach out and touch somebody that's got this very limited license in a case like this with this level of testimony, I like to think we're going to be looking at things a little more serious than this. Also, I have to mention the order that you entered in the COVID world indicating you have a right, an absolute right, to have an in-person hearing. I can't imagine anybody having an in-person hearing where they're not going to want to be able to confront people, which is really, I think, what the court's intent was when you made sure that's in the rules. And I think that's certainly how we operated pre-COVID. And this suggestion that we do it all the time, that we have these Skype hearings, that we do it on the phone, and we're agreeing to have out-of-state people testify in this way, is simply not my experience. I've never seen it. This is the only time I've ever seen it. And then I got an opinion that really befuddles me even now to read it. I don't know what they were saying. We took this testimony, but you don't have to consider it at all.
But the three violations that they found don't turn on her testimony at all, I don't think. The one I was working on earlier don't need her testimony at all for that. Now, you may argue that it wasn't a violation, but the contract explicitly said that no services would be rendered until the first payment was made, and then he didn't follow the contract. Now we don't need the client. That seems to me at least gives rise to a potential violation, regardless. And I think there's 3 violations in total, or maybe there's more. But if I walk through each one of them, we don't need any other testimony other than what the record. It's really, frankly, undisputed, I think. And so, can we deal with this case, deal with the violations, and not, I mean, do exactly what the board did, namely, we don't need to consider the remote evidence.
You may answer and then wrap up.
If I could, and I'll do my best to wrap up and to answer that question. The reality is that at this situation, do we just tell the respondent lawyers, just take the fifth, don't testify at all? I mean, we don't. Obviously, they testify and they give their version. And his sworn testimony, which is in the record, I think totally satisfies what he did and why he did it. I don't think anything should be sanctionable as to what he did. If there's going to be a sanction, it would be far different than the one that was entered. And I think at this point, the case ought to be dismissed. If there's going to be any sanction, it ought to be a private admonition. The idea that we're going to sanction this type of conduct in our licensed lawyers who are practicing remotely, who may or may not have come across the radar somehow, I think we've got better things to do, and I think this court, I'm quite convinced, has a great deal more to do than this. Thank you. We believe that this ruling should be reversed.
Thank you. I believe this case has reached its conclusion for argument. Thank you very much, and it is officially submitted, and we will adjourn court for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.